Hi, my name is Eileen Mostricht, and today I wanted to talk about this idea of putting your adult child on the deed to your house as a joint tenant with right of survivorship. I do get this question quite a bit, and I wanted to just parse it out a little bit. So, joint tenants with right of survivorship in Florida means that when one of the owners dies, the other one then just owns it automatically, 100% without probate. So, obviously, that's a good result. There are some consequences, though, to this that you would have to consider. So by doing what the good news is though, is that as long as you're still living there, you the adult, then even if you do put your child on as a joint owner, you still do maintain your full homestead exemption and your Save Our Homes cap. But the problem is, or one of the problems comes in with this issue of basis. Basis is what is considered your purchase price when calculating the capital gains tax. If you bought this house for $50,000, for example, in Fort Lauderdale in the 70s, which is a real thing, and now it's worth, when you pass away, it's worth $1 million. If the child is not a joint tenant, let's say they just inherit the house, they will get a full step up in basis to the date of death value. So if it's worth $1 million at your date of death, that's going to be considered their purchase price for purposes of calculating their own capital gains tax at the point that at some point down the road when they sell the house. So that is a huge tax advantage to them. If you put them on as a joint tenant with right of survivorship though, they're only going to get a 1/2 step up in basis. So that could be a really big deal. The other issue is with the long-term care Medicaid program. If you do that transfer to the joint tenancy with your child within 5 years of needing the long-term care Medicaid program, that is going to be a penalizable gift. I did talk about in a prior video how we can cure gifts in Florida. Your child could just deed it back to you, but to the extent that that's not possible, sometimes for whatever reason that's not going to work out, that would be a penalizable gift. If you did that more than 5 years before you needed the Medicaid, then it wouldn't matter. The better solution to all of this is to do a ladybird deed. A ladybird deed then it says that when you pass away, the house goes to a person or persons that you've named as the remainder beneficiary in that ladybird deed. It avoids probate. The child will then get the full step up in basis, which is excellent for capital gains purposes. And it is not a problem for Medicaid. It's not a present transfer of property. It's only something that you're writing about that's going to happen in the future. So it is fine for Medicaid. So if you are thinking about this joint tenancy or putting an adult child on your house, think about it carefully and talk to an attorney about the alternatives. And really, a ladybird deed is probably going to be the better alternative.